everyone. And back again, we are with the part 3 of our service law series, wherein Mr. P.S. Rajagopal, as we always say, akin to his name, that he's vast knowledge on service law and all other fields, speaks volume that his sessions on the YouTube have made its special place and in the hearts of the people who actually want to understand service law. And the service being provided by Mr. P.S. Rajagopal to the nation at large for empowering with the legal knowledge is also, which will go down deep in the history for that particular. Understanding service law always, for a common man who's practicing in the field of law or student, always has its own challenges. But if you can get the blocks unblocked by a person of stature of Mr. P.S. Rajagopal, shows that you can understand. Today's session we take forward with the recruitment process, weightage, considerations and safeguards. We can all say that once we heard the session from Mr. P.S. Rajagopal, and we can be guarded in the court of law once you are as a lawyer or itself or a respondent doing that, because you can understand the pros and cons. The weightage in your arguments always get better. Your weightage of the knowledge definitely gets better. And you can be recruited in the new domains and new eras of knowledge when Mr. P.S. Rajagopal is there. Being a weekend, and that too, when he has a schedule ahead, still his desire, sharing the knowledge, be neither impress, but we can only say that we are always his knowledge. Over to you, Mr. P.S. Rajagopal. Yes, sir.
Thank you. I'm back for all of you with chapter 3. That is dealing with process of recruitment and weightages that can be assigned to various tools of assessing suitability. Then what is meant by consideration of a candidates according to the constitutional scheme, and in case of any violation of individual rights, or for that matter, even collective rights of the candidates in a recruitment process, what are the safeguards that are available? By now, it must have been very clear to every one of you that any recruitment to public employment will have to be informed by the bedrock requirements of Articles 14 and 16 of the Constitution of India. When I say Article 16 and do not specify any clause thereof, it obviously means the recruitment process will have to be in conformity with even the rules regarding reservation, both as regards quantum and also regards the manner in which the reservation is provided. Now, what is this recruitment? Where it starts and where it ends? On this aspect, we should be very clear. If you refer any pleading judgment and go to find means enlistment, and it commences with issue of advertisement or employment notification inviting applications, and ends with publication of the select list and its forwarded to the appointing authority.
1 minute, kindly check your internet. Probably there's some buffering. Just ask Jen to do that. Meanwhile, you can continue.
Okay.
Or there's a lack of the way you speak, there's a breakage.
Now I think now it should be clear. There was some problem with the internet, and
Yeah.
but it is better to not go by that definition, which is legally correct, but conceptually may not be complete. First requirement for initiation of a recruitment process is existence of vacancies, and more importantly, the decision of the appointing authority to fill up the required number of posts. Therefore, though we can call it as a step prior to recruitment, technically, in substance, the first step in recruitment is the decision taken by the appointing authority to identify the number of vacant posts, and after those vacant posts, decision of the appointing authority to fill up the requisite number or specified number of posts. Once this exercise is completed or decision is taken by the appointing authority, then the locate from appointing authority to the selecting body. In most of these recruitment rules, we find a provision as to who shall make the recruitment, which agency shall make the recruitment. For that, if it is a body within the employer organization, they may say that selection committee, or in most of the service concerning the government service, there will be a specification as to the agency which will conduct the recruitment. Commonly, it will be Public Service Commission, or in some states, for some categories of posts, we also have staff selection commissions or staff selection boards. Service selection boards as the same function, namely recruitment. After a decision is taken by the appointing authority and the vacancies are entrusted to the recruiting body, the first requirement step to be taken by the recruiting body is issuance of advertisement, or what is commonly known as recruitment notification. It is settled that if constitutional value of equal opportunity in public employment has to be fulfilled, any appointment, even if it is temporary or ad hoc, it will have to be made only after providing opportunity to all eligible candidates to compete if they so desire. Therefore, first essential requirement of any recruitment process is issuance of the recruitment notification. What should the recruitment notification state significance? Because it is more or less settled that any condition which is not stipulated in the recruitment notification cannot be insisted upon. And there is one more requirement, that is, the recruitment notification must be in strict compliance with the requirements of the recruitment. Keeping these two safeguards in mind, or essentialities in mind, what a recruitment notification should contain. Recruitment notification, of course, should contain number of posts, nature of the post, nature of appointments, whether it is temporary, tenure-based, or permanent, and the qualifications stipulated for the post. Qualifications are of two types. One qualification is academic qualification. That is, a graduate in any branch of study from a recognized university, or a particular technical or professional qualification like LLB, BE, or B architecture, or MBBS, or MS. Then any particular standard of academic attainment. For example, in this post of assistant professors in any university or college, minimum prescribed is 55% in the postgraduate course of the relevant subject. This will have to be clearly mentioned. How many years of teaching experience, if it is a post and teaching line, or workshop experience, if it is a technical post, or working experience or administrative experience, as the case may be. The experience requirement also will have to be mentioned. Then we have age requirement. What should be the minimum age and what should be the maximum age? Of course, these days we are having posts for which there is no maximum age requirement. As for example, if you take the UGC regulations for minimum standards in teaching in the graduate and postgraduate courses, or even medical council norms, there is no maximum age limit because of two things. One is they require teaching experience, therefore higher the age, higher the teaching experience, it would be in public interest not to stipulate any higher age. But it goes without saying that nobody who has crossed the age of retirement can still compete for recruitment. For minimum and maximum, we have the power of relaxation. In most of the governmental rules, or even in professional college rules, we will find a provision for relaxation of certain qualifications. What are the relaxations for business? Say there is there are two types of experiences when it comes to appointments of teaching staff in university. One is research experience, another is the teaching experience. One aspect of relaxation would arise, that is where, let us say, PhD in the relevant subject is the stipulated qualification. There would be a relaxation where though a candidate has not acquired a formal PhD degree, he might have published work of such a high standard, which, in the opinion of an expert body, may entitle him to have the requirement of doctorate degree relaxation. Another type of relaxation is to ensure mobility of employees from one public organization to another public organization. Normally, there will be a provision in the service rules that to the extent of service rendered in a analogous post in any other public sector organization, maximum will be relaxable by the number of years of service up to a maximum of a particular number of years. This is age relaxation. Relaxation can be of a myriad varieties. But the basic requirement is that if there is power of relaxation available in the service rules, it should be stated so in the recruitment notification, and it must be specified as to what are the relaxations available, what is the extent of relaxations available, what are the conditions subject to which the relaxation would be available, and who is the authority competent to decide the extent and applicability of relaxation. Relaxation must be available in the recruitment book, and it must also be stated in the recruitment notification. There are a number of judgments which say that relaxation will have to be strictly in accordance with the recruitment book, and relaxation, if available, to the extent of availability must be clearly spelled out in the advertisement. The requirement of spelling it out in the advertisement is that object of any recruitment is to have the best candidate available and offering his candidature to be selected. If relaxation norm is not made known, some of the candidates who are eligible for relaxation may not apply for the post looking to the requirements in the advertisement. Therefore, that is another aspect. And why it is very necessary to state every requirement of the relaxation as also the recruitment rule in the notification is that there are two essentialities to be complied with in any recruitment to public posts. First requirement is it must be in consonance with the recruitment rules. Second requirement is once the process of recruitment starts, or as they say, once the game starts, the rules of the game cannot be changed. Therefore, the advertisement must be complete and it should contain all essential data or all essential information to enable every competing candidate have an equal opportunity. Then it should also stipulate what is the last date for submission of applications. These days, there is one more requirement because most of the recruiting bodies insist on submission of applications online. Therefore, candidate is expected to know, is required to know not only the date on the last date on which he can submit the application, but also the first date from which the application will be available on the website for download. These are the essential requirements of the advertisement. There is one more requirement, that is, all right, we stipulate he must be a holder of PhD or equivalent. He must be not more than 35 years of age. He must be, in case he wants to claim reservation, he should obtain the candidate. There is one another aspect that requires to be stipulated, that is the relevant date with reference to which the eligibility will be computed. That is, suppose on 1st of May, I don't want the 1st of April because though it is beginning of any financial or accounting year, let us not have, because these days a common complaint is there. All these recruitment exercises are fooling exercises. Therefore, I don't want to add to that opinion by choosing 1st April as the relevant date. Let us say 1st May is the date on which the advertisement is issued. Last date for submission of the application is, let me presume it is 31st of May. The notification should say on what date the candidate should be possessing the qualifications. This question arose in Rekha Chaturvedi's case, which arose from a recruitment conducted by Rajasthan University. The recruitment notification did not specify the date with reference to which the eligibility conditions will have to be satisfied. The selection committee had taken the eligibility date as date of conducting the interview or date of selection. Supreme Court said it cannot be. Date of selection will always be uncertain. Nobody knows on what day the selection would take place. Therefore, a definite date has to be prescribed for avoidance of arbitrariness and to ensure that every eligible candidate would be in a position to apply. And it said, if preferably notification should stipulate the date. If notification does not stipulate the date, it is not that there is no date, but the date would be last date prescribed for receipt of the applications. Therefore, if any advertisement does not mention the relevant date with reference to which the qualifications eligibility will have to be ascertained, that date, it is not judicially settled, will be the last date prescribed for receipt of the applications. And another important requirement of recruitment notification is, what are the certificates that will have to be annexed to the application will also have to be stated. Many times this arises. This question arises before the courts. What the usual complaint is that I could not get the certificate on time. Therefore, I have submitted the application late. But I had the qualification even earlier to the last date. Therefore, my candidature has to be considered. This question, initially there was some confusion. Confusion in the sense, in a case arising from admission to professional colleges in Kerala, Lordship Justice Krishna had taken a view that possessing of the qualification does not depend on possessing of the certificate or submission of the certificate. Therefore, we have to take a pragmatic view, and even if the certificates are produced after the last date stipulated for submission of applications, they will have to be taken into consideration. But over a period of time, law slowly moved towards strict compliance with requirement of the recruitment notification, because any concession or relaxation shown to one would result in injustice to many others. Therefore, in Bedan Talukdar, Supreme Court took the view that once a recruitment notification is issued and a time schedule is stipulated therein, the recruitment will have to be completed in accordance with that stipulated time frame, and it cannot undergo change thereafter. And this applies to reservation certificates also. In Bedan Talukdar, the question involved was submission of disability certificate to claim reservation under Equal Opportunities for Persons with Disabilities Act. A slightly discordant view was taken in Rajkumar Gijroya. Rajkumar, or what is Gijroya? In Gijroya's case arising from the state of Delhi, where the advertisement was vague. It did not stipulate that claim certificate for reservation has to be submitted along with the application. But while publishing the select list, the candidature of some persons who had not enclosed the reservation certificate along with the application was rejected. Then Supreme Court took a view, invoking Lordship Justice Krishna Iyer's view in education law into service law, and said that a liberal view has to be taken. A candidate belonging to OBC will belong to OBC with or without certificate. Therefore, the late submission of certificate cannot be used by the candidate. Of course, now subsequently 2 or 3 judgments of the Supreme Court have set the confusion at naught and said that Rajkumar Gijroya is limited to facts of that case, and the law as it stands today is that any reservation certificate submitted after the stipulated date in the recruitment notification, it cannot be taken into consideration. The latest case, which arose from state of Bihar, that concerned submission of a certificate of NCC B certificate, that is Ramkumar Gijroya for the discordant, that is discordant view, and then now the present view is state of Bihar versus Madhukant Ranjan. This was decided, I think, on 16th of December 2021, and therefore that view is the latest view, and it is in line with the consistent view that is being taken by the Supreme Court in the matter of compliance with recruitment notification, terms of recruitment notifications, and this would avoid any arbitrariness, any manipulation, any favoritism, and it will ensure a level playing field. Now coming to the question of what are the tools to determine suitability of a candidate, merit of a candidate who is competent. There are several tools. One very simplistic view that can be taken. Suppose a BA degree is stipulated as a qualification. The merit of the candidates would already have been determined by the university by awarding marks or grades while awarding the BE degree. Take the percentage of marks or the aggregate marks secured in the qualifying examination, that is the degree examination of the concerned branch. That is one very simplistic view, but that cannot be a rational view for several reasons. Suppose in a state, there are, these days I think no state is having less than 20 universities. Suppose in a state there are about 20 or 25 universities awarding BA or BSc or BCom degrees. Each of those universities will have different standards. Each of them will be having different norms of evaluation. Therefore, even in the matter of admission to postgraduate courses in medicine, Supreme Court said long years ago through Justice R.C. Lahoti in Gopal Tirthani's case, suppose a qualifying examination is prescribed and there is more than one university in the state awarding that qualifying degree, then to determine the merit of the candidates on a uniform basis, we cannot go by the marks awarded by the university in the qualifying examination. A written competitive examination is necessary. That has been adopted insofar as service jurisprudence is concerned, even earlier to public. Therefore, the most readily accepted rule of determination of merit is a competitive examination conducted by the recruiting agency. The next question would be whether written examination would be adequate or whether it can be the sole tool to determine the merit of a candidate. When we are selecting a candidate for public service, it is not the academic merit alone that we look at. We look at various other components of his knowledge, like current affairs, general knowledge, or what is called as transactional knowledge, or the candidate being able to relate to the present current affairs of the society. Several such components go into determine the suitability of a candidate. Some of them can be tested by written examination. Some cannot be tested by the written examination. So to assess the personality of a candidate, this interview test has been introduced. Lordship Justice Chinnapreddy, in Liladhar's case, first propounded the advantages and disadvantages of various tools that are used in the recruitment process. He said, written examination is most commonly accepted, but the deficiency of written examination is that it can at best test the intellectual knowledge candidate, but it does not judge the candidate himself. Or to use the words of Lordship Justice Chinnapreddy, while written examination tests the knowledge and capabilities of a candidate intellectually, the interview test judges the candidate himself. And he said, for a effective recruitment, the twain shall meet. There could be both written examination and interview. But interview is always suspect. If you meet, and as a matter of fact, as advocates, we would be coming across most of the times only unsuccessful candidates, because it is unsuccessful candidates who sets the law in motion. He is the person who challenges his non-selection. Any one of them who comes to an advocate, they say that, sir, I have been awarded very low marks in the interview. I have secured 90% in the written examination. Sir, person who was my batchmate in the university, who is a dead according to me, he has got more marks in the interview than me. All these type of complaints do come. But the solution lies in improving the credibility of the interview test rather than seeking to eradicate the interview as is being presently done by different state governments for I don't know what reasons. But the balancing exercise is what is the percentage of weightage that will be given to written test and to interview. When this question comes, almost always, the unsuccessful candidate would rely upon Ashok Kumar Yadav. Where in Ashok Kumar Yadav? The Supreme Court said, when there is both a written examination and interview, weightage of 33% of marks for interview appears to be on the higher side. He did not lay down in that application, in that judgment, any form of universal application. On the other hand, it specifically said there is no magic formula as to what would be the weightage for written examination, what would be the weightage for interview. It depends on the talent pool from which you are making the selection, the level of the post for which you are making the selection. It also depends upon whether interview is used as a sole test or whether it is used as one of the tests in conjunction with other modes. In subsequent judgments, this has been elaborated by saying, suppose the recruitment, even in Ashok Kumar itself has, or even earlier judgment, Leela, in Ashok Kumar, it was Justice Bhagavati who wrote the judgment for 5 judgment. The first judgment on this interview, weightages and all that is in Leela versus State of Rajasthan, authored by Lordship Justice Chinnap Reddy. That itself said, suppose at an entry level, we are recruiting candidates from universities, fresh graduates from the university. The ideal test to measure the merit of the candidate may be written examination coupled with a minor weightage for interview. But let us take the case where we are recruiting candidates for the post of professors. Candidates would always, by then, would be mature, more than 45 to 50 years of age. They have enormous years of experience. In such cases, written test may be a harassment candidate, and at the same time, written after that harassment also, written examination may not yield correct results. Therefore, as we go up the ladder, interview could be either the sole test or the dominant test. In CP Kalra versus Air India, the 40% weightage for interview was up. Subsequently, in Andhra Pradesh State Financial Corporation, where the interview was the sole test of measuring merit, it was also having regard to the talent pool and the level of the post for which the recruitment was being made. Therefore, the only certain answer I can give as to what is the extent of weightage that can be given for interview is it depends on the nature of candidates who are considering, whom you are considering, level of the post for which the selection is being made, and the experience that the candidate would have gained by then, and several other complex factors will have to go into it. There is no magic percentage which would fit all situations. Then consideration, it has to be in accordance with law. Consider what is in accordance with law. Law means in relation to recruitment, recruitment rule is the law, recruitment notification is the guidance, and Article 14 and Article 16(1) are to be borne in mind, which ensure that every candidate has a right to be considered in accordance with law. He may not have a right to be appointed, but every candidate has a right to be considered in accordance with law. What is consideration in accordance with law, apart from compliance with the recruitment rules? Yes, there must be no bias in any member of the selection committee. Now, this is a concept which is difficult to be established, but easy to be alleged. But there are certain circumstances where bias is obvious. The first case on this aspect of the matter, that is about bias, is the case of AK Kripa, where the selection committee was meeting to select candidates for Indian Forest Service. From the State Forest Service, it was appointment by selection to the Indian Forest Service. In that selection committee, Chief Conservator of Forests of the state is a member of the selection committee. In that case, it so happened that the post of Conservator of Forests, Chief Conservator, was vacant, and there was one in-charge Conservator of Forests who himself was a candidate for selection to IFS. Then what is required to be done? What he did was, he participated in the selection as a candidate. He participated in interviewing the candidates in respect of all other candidates except himself. Therefore, the argument advanced was, Nakshabandi may be a candidate. He might have interviewed considered all other candidates, but he himself did not sit in the selection committee when his candidature came. Supreme Court said that all these arguments will not work and bias is obvious. Then number of times we come across cases where a relative of a candidate will sit in the selecting body. Therefore, normally what these recruitment agencies do is that they obtain a declaration from the examiners and the interviewing persons that none of their relatives, close relatives, are candidates in the process of recruitment. Classic case that arose in respect of this question of bias is again Ashok Kumar Yadav, to which I have to go back. In Ashok Kumar Yadav, a relation of one of the members of the Public Service Commission was a candidate. The challenge to selection was on the ground that one member of the selecting body being on the principle of bias as laid down in AK Kripa. Supreme Court made a slight deviation there, invoking the principle of the object of necessity. Now what happens? The Public Service Commission is entrusted with the selection. There are required to be a specified number of members of the commission interviewing the candidate. If the members of the commission are disqualified from sitting in selection process on the ground that one or the other relative of them is participating in the selection process, the whole thing becomes unworkable. Therefore, the Supreme Court said, when it comes to a body like Public Service Commission, it is not necessary for the member to recuse from the selection process itself. All that is required to ensure non-arbitrariness in such cases would be that member will not interview the candidate who is related. He will be interviewed by other members of the commission who will not disclose the marks given to that particular candidate. Therefore, the bias in selection is also subject to the doctrine of necessity, which can be invoked to ward off the charge of bias or sometimes even breach of natural justice. This is the broad principle. Then what are the safeguards? If the interview test is essential. Knowing as we do the arbitrariness that could result in interview process, at least I know personally some of the cases where interview becomes a sort of horse trading. Candidate knows what was the cutoff point in the last selection. Candidate knows what are the marks secured by him in the written examination part of the competitive examination. Then the question would be, how many marks he should get in the interview to get selected to what post. This can result in whatever you call it, horse trading, or name a label you may give as you please, but the selection would not be fair and just. As a safeguard, the Supreme Court said that, in fact, it only adopted the affidavit filed by the Public Service Commission that marks secured in the written examination part is not disclosed to any member of the interview committee. Therefore, the interview committee members did not know what is the marks that candidate requires to get a particular post. Of course, subsequently, rules have been amended in most of the states to the effect that marks shall not be disclosed even to the candidate himself until publication of the final select list. This is the principle followed by the UPSC, which most of the state public service commissions have now adopted. Then we come to the safeguards in law. What are the safeguards? If an appointment is made without issuing advertisement, it would be a stillborn baby. In such cases, to borrow the words of Lordship Justice Majumdar, even subsequent promotion, confirmation, whatever is granted to the candidate, it would be like decorating a stillborn baby. They will be of no consequence. A more moderate language has been deployed in state of Orissa versus Mamta Mohanty, where it said, suppose a candidate does not have eligibility qualifications, or suppose the appointment is made without issuing an advertisement, or appointment has been made relaxing the impermissible. In all such cases, appointment itself is void of issue, and subsequent events do not sanctify. That is, if an appointment is bad at the threshold, any number of years he spends on the post and any number of promotions he gets subsequent thereto will be of no consequence. And 0 multiplied by 0 will remain as 0. Therefore, neither concept of adverse position nor long years of service would be useful to him. Then there is a oft repeated principle, that is, participation in the selection process would disqualify the candidate from questioning the selection process, or what we call as estoppel by participation or acquiescence by participation. It is true. Suppose your case is that a particular qualification could not have been stipulated. The advertisement had stipulated that qualification, or the advertisement was defective in the sense it gave certain confusing signals. In such cases, if you want to question it, you have to question it at the threshold. By participating in the selection process, you acquiesce in it. Thereafter, you will be stopped from questioning the selection process on the ground that you are not selected. But at the same time, there are cases and cases where the principle of estoppel cannot be invoked. It was stated in Shaktiraj versus Rajkumar that where there are glaring illegalities, the principle of estoppel cannot be invoked. Now I conclude my submissions referring to what are the powers of the recruiting body or the selection committee to deviate from the rule or the procedure stated. One thing I must confess is that most of these judgments have come in recruitment processes conducted by the high courts themselves. Though high court says what is Article 14, what is Article 16(1) to the whole world, when high court exercises the power, sometimes these glaring illegalities occur. You must have been by now aware of the famous oft-quoted statement that rules of the game cannot be changed in the midstream. K. Manjushri was a case where the selection was done by the High Court, and the selection involved both written examination and interview. After the interviews were over, High Court found that the merit list was not to its satisfaction. So it introduced, after the interviews were over, it stipulated minimum for interview. It resolved that to be included in the select list, we will include only those candidates who have secured this minimum percentage in the interview. Then Lordship Justice Ravindran, speaking for three-judge bench in the Supreme Court, held that changing the rule of the game after the game is played is impermissible in law. Then even earlier to it, the glorious case of how the High Court can err in making the selections is laid down by the Supreme Court in the Shukla's case, that is Shukla is just a minute. Sorry for the. In Umesh Chandra Shukla. Umesh Chandra Shukla versus Union of India is a case dealing with selections made to the post of sub-judges by the Delhi High Court. See, in Constitution, there is a subtle difference between district judges and sub-judges. Insofar as the district judges are concerned, it is the High Court has greater leeway. But when it comes to sub-judges, the appointing authority is the governor, rule-making authority is the governor, and governor is shorthand form for the government. What happened was the 50% was the stipulated minimum in each paper of written examination. After conducting and evaluating the performance written examination, High Court found that certain candidates who have scored very high in some of the papers have fallen short of the minimum in one or two papers. Because of which, according to the view of the Supreme Court, view of the High Court, meritorious candidates were being ineligible for Viva versus stage. Then the High Court decided that in such cases, we will add 2% by way of moderation to those who have fallen short of 50%. Therefore, they added 2% of marks by way of moderation, made all of them eligible for interview, and conducted the interview. Another thing that was done was that minimum for interview was also fixed by the selected. First one was done by adding 2% mark was done by full court of the High Court, full court meeting of the High Court. Prescribing minimum was done, minimum in the interview was done by the selection committee of the consisting of High Court judges and maybe some others also. Lordship Justice Venkatramayya speaking for the court, he said, High Court could not have amended the recruitment rule indirectly by adding 2% by way of moderation. Yes, moderation is an accepted exercise to equalize the merit when it comes to remove the dove and hawk effect in evaluation. Different standards of evaluation are adopted by different examiners. But that was not the case here. Here it was added. While rule stipulates that 50% is the minimum in the written examination, by your resort to moderation, you have amended the recruitment rule, making those who secure 48% also eligible for waivers. Therefore, the High Court had no power to resort to this type of moderation. Second thing is said, the selection committee has no power to introduce any element which is not there in the recruitment. Suppose recruitment is silent, rule is silent in any aspect, it may, by virtue of its inherent power, selection committee may devise its own procedures and fill in the gaps. But where the rule is clear, no minimum in the interview, selection committee in introducing the minimum marks for the interview. Therefore, on both these counts, first annulling the resolution of the full court, thereafter annulling the decision of the selection committee, the Supreme Court had to strike down the selection made by the Delhi High Court for appointment of sub-judges in Delhi subordinate judiciary. Therefore, this judicial review is the greatest safeguard that we have here. The courts are helpless. Like, for example, how much marks the candidate deserves. High Court cannot sit as selecting body and say that the assessment made by the selecting body is wrong and we will assess the candidate. No, that is not the role of the judicial review. Then what are the weightages? Like as in Ashok Kumar Yadav, where they found the weightages to be on the higher side. Even then, the Supreme Court did not annul the selections made. It only laid down law for the future. But in Umesh and Shukla, the Supreme Court set aside the selection list because it was contrary to the very recruitment rule and directed the High Court to prepare a fresh merit list drawn in accordance with the law declared in Umesh and Shukla. Therefore, there are certain areas where the judiciary cannot intervene except for proved mass-scale fraud which has vitiated the entire selection. Article 14 and 16 of the first safeguard. Insistence on adherence to recruitment rule is the second safeguard. Rule against bias is the third safeguard. And ultimate safeguard is the judicial review. But still, when it comes to measuring the merit and suitability of the candidate, High Court cannot sit in the armchair of an expert and then substitute its view on suitability to the view taken by the selecting body, which is expert in the subject. Friends, I have tried to cover the processes, weightages, considerations, and safeguards in the recruitment process. I am grateful to you. Now, over to you.
Yeah, sir. I will just ask Trikram also to unmute. So as usual, the session took everything, what could be the consideration, etc. And before we take the questions, let me see as to whether we have any questions in the chat. Yes, sir. Prabhakar says, can one challenge the appointments if recruitment is not following the norms of minimum qualification requirement at that time? Can one challenge recruitment in the year 1992?
Of which year?
Senior college aided by the government.
If the qualifications prescribed are not fulfilled by the candidates, the appointment would be void. Or if the notification itself is contrary to the recruitment rule, then also the voidness arises. But the question is, after how long you can challenge? The law on this is any challenge to the appointments or recruitment should be made within a maximum period of 1 year from the date of appointment. Even where, for example, the Administrative Tribunals Act prescribes a limitation of 1 year. In a very, of course, it is a very isolated case, but still, in a case which arose from the state of Karnataka, where the application had been filed before the tribunal within the limitation of 1 year, tribunal had taken a view that in challenge to the appointments, ground realities cannot be ignored. Though the application is filed within the period of limitation prescribed, still it suffers from laches, inasmuch as more than 6 months after appointment, the challenge has been raised. And that judgment was confirmed in the Supreme Court in K. Prakash versus State of Karnataka. Then there is another judgment which came from Andhra Pradesh High Court. There the appointments were to subordinate judiciary. There also, Lordship Justice P. Venkatram Reddy, he had taken a view that though it is in less than 1 year, ground realities cannot be ignored. Therefore, except in cases where something is vitiated by fraud, and it is a bona fide error, even with respect to qualifications, the general judicial view appears to be that if a challenge is raised beyond 1 year, it should not be accepted. But there are cases where, suppose the whole thing is a fraud, and fraud comes to light after 4 or 5 years of appointments. Even then, even in such cases, the courts have said mercilessly send them out. And in dealing with challenges to the recruitment, the courts have adopted 2 distinct standards. One is the cases where challenge is raised before the appointments are made. That is soon after select list is published. Second is where the fraud is light after the appointments are made. After the appointments are made, the case is where which arose from Punjab, appointments made by a particular chairman of the selections made by a particular chairman of the Public Service Commission. There are ultimately some appointments of innocent candidates who have worked for 3 to 4 years or 5 years. Those were saved. But when before appointment, the challenge reaches the court, alleging malafide, fraud, large-scale rigging, then courts have generally taken a view that the inclusion of a person's name in the select list does not give him an indefeasible right to be appointed. Therefore, at that stage, if the select list is annulled, no tears need be shed for the candidates who have got selected, though innocently, in a batch of frauds. This is the general yardstick that is applied by the courts. And as usual in service law, everything depends on facts and circumstances of each case. And that is the hallmark of service law is facts and circumstances of each case. And how you present the facts and circumstances of each case, and what is the predominant fact or circumstance in a particular case would tilt the balance. I would not say that tilt the justice, it would only tilt the balance in favor of one or the other group. Because
Yes, sir. So we will try to wrap it off before you have to leave for 7 o'clock. So like you were taking across all these judgments, the common questions which again arise, like Ashok Yadav, Leeladhar, then a recent judgment of Dr. Mehta, all this, and how marks can be given for the interview, whether marks can be given or not, whether the marks in respect of a class 4 post can be given for an interview, or let's assume there's a teacher, because in one of the judgment I was reading where there's no interview, then in that respect, if you don't have the interview course or you don't have the recourse to the interview, and let's assume he comes out that he's stammering or he's not in that good communication, then in that eventuality, they said interview is the best recourse to test the best things. Now, first things first, we come back to the basics for the professional legal skill sets, what we take from people like you. We would like to understand how to remember all these judgments from way back from 81 Leeladhar, then Ashok Yadav in 94, then Dr. Mehta in 91, now the recent judgment of the latest Supreme Court, to the effect, how do you juxtapose all these judgments and where do you figure in that this 12.5%, 33%, 50% has to be considered, and where to put, how do you fit the round peg in a round hole rather than putting a square peg in a round hole?
I would cite you the example from home. See, for selecting a civil judge, written test in the interview are there. For selecting a district judge, also written test and interview is there. For selecting high court judges, there is neither written test nor interview. At the same time, you cannot say that selection of district judges has been the best and selection of high court judges or Supreme Court judges is bad. There are goods and bads in both. Therefore, the safest test is to make an overall assessment on the basis of age group of candidates you are looking at, the experience you have stated, that is the professional experience or whatever experience, and having regard to the talent pool, age group, and the requirements in the candidates you are looking at, decide which is the best tool to determine the suitability. It is an assessment, an objective assessment that is required to be made, having regard to taking a holistic view of requirement of the service and requirement of the post which you are making a appointment. Now take the case of my director of a public undertaking. You will be considering candidates above the age group of 50. There would be candidates who have worked in different enterprises almost to the extent of 20 to 30 years. If you ask them to take an interview, they take a written test, they may not even apply for the post. They will say, I am happy where I am. And who are to evaluate my papers? All these questions of ego as also questions of pragmatism would arise. Therefore, a realistic appreciation of all these components that go into to decide which is the best method for that post is the solution. And though normally judiciary would not interfere in the matter of tools of selection, if the tools of selection are patently arbitrary or manifest arbitrariness is demonstrated, they can interfere. For example, it happened in the case of appointments to tribunals. Now, Tribunal Reforms Act has come. Even challenge to it is pending before the Supreme Court. Therefore, several aspects go into decide the recruitment methodology. And there is no, from 1950 onwards, if you take, for example, the Periyakkaruppam, it was the case of interview for admission to professional course. From there, we came to Liladhar. From there, Ashok Yadav. Now we have latest from, I think, some Northeastern State Public Service Commission, where they said interview should be videographed. Like a heroic judgment, adventure of the Supreme Court, which said live stream the court proceedings. Within a year of that judgment, we are realizing what are the horrors of live stream. I am confident during my lifetime, courts will realize the heroic blunder committed by them by resort to this live stream. See, these are matters which myriad factors in which we have to take into account. For example, in the courts, most of us, we know an honest opinion of the advocate is sought by the court, though he is appearing for a particular party. I have come across this situation number of times in the court. Court would say, yes, Mr. Rajagopal, you are enough for your client. Now tell me your honest opinion. Then, in live streaming, can I give an honest opinion? This is from advocate side. In another case, in the very earliest phase of my career, one workman's reinstatement and his entitlement to back wages was being very hotly argued. I was for the workman. Then another established labor practitioner was for the management. After hearing the matter for 3 hours, spread over 2 days, judge passed on a chit to me. In that it was written, your client will be entitled to back wages for this period only. Then I gave a smile of acceptance to the judge and returned the chit. That chit contained a proposition which neither accepted my argument fully nor management's argument fully. Could I have given that concession even with a silent smile? If it was a era of live streaming, where passing of a chit is visible, my reading the chit is visible, returning the chit with a smile is visible. Imagine, see, it is easy to be popular. But it is difficult to be pragmatic. And judiciary, if the justice delivery system should be efficient, should be pragmatic and not theoretical. Theoretical and theatrical, they will never lead you to pragmatic balance in the society. I'm really afraid that we are disturbing that balance. All said and done, even in an open court system, everything cannot be open. You are risking the advocates. You are risking the values of judicial delivery. You are risking openness by saying to be open. Openness should be in exchange of views, not in choice of the platform. Choice of the platform is one openness. More important than that is freedom to express genuine views without the fear of reprisal is more important. I am a Democrat. I don't say that openness is bad. But at the same time, openness is not a panacea also. Sorry, because I think I took you elsewhere.
No. I was just thinking, I was reminded every coin has two sides. Therefore, some live streaming has its own advantages, and as you rightly said, so we all will, with a flux of time, come out and decide as to how things shape up. And they say that only the experimentation leads to the right path, until unless they say that it's better to try and fail rather than failing to try. So we are all
churning is required.
Churning brings the best of the butter.
Yes.
So before we part for the day, our knowledge partner Trivikram is here. I will ask Trivikram
to share his insight. I have one small question, sir. Can I ask, sir?
Yeah.
With the permission of Rajagopal, sir. Can I ask one?
Yes.
Sir,
permission of Vikas.
Okay. Sir, in fact, you said, sir, if selection process has to be challenged, it has to be challenged within 1 year, as per the Administrative Tribunals Act, sir. But you also said if the fraud has come to light after some 3 or 4 years of the final selection list, sir. If the take for example, I was repeatedly asking for information under the Right to Information Act, that was denied. That was necessitating me to file first appeal and then come before the Karnataka Information Commission in second appeal. And for an appeal to get disposed of before Karnataka Information Commission, it will take more than 1 year, sir. Before 1 year, no information can be we can get from Karnataka Information Commission. So 3-4 years has elapsed, sir. Only now I have come to know that though I have written correct answers in my answer paper, those marks have not been allotted to the correct answers. Only recently, after some 4 years of this for this publication of final selection list, I have come to know that marks have not been allotted to the correct answers written in my answer paper, sir. Now, what is the option that is open to me, sir?
It is reliance on Right to Information Act as a justification for delay is not
So you will have to unmute yourself.
Rajagopal sir, you will have to unmute yourself.
No, till now, host was not allowing me to unmute.
So as long as I'm a host, I will be a good host. I will allow every guest to be receptive of your knowledge.
My voice is loud, but then it cannot go beyond the electronic controls.
No.
Saying that I got the information only under the Right to Information Act about my performance. is a very difficult thing to believe. Because normally, when a candidate writes a examination, he would know what is the mark he is expecting, or he can reasonably expect. If his expectation was something totally different from marks he has secured, which he would know on the day the select list is published. Because all public service commissions give candidates' own marks after the select list. If he had a genuine feeling that he has been deprived of less appropriate marks, nothing prevented him from challenging it. You can always, with appropriate data, if you are able to convince the court that injustice has been done, persuade the court to summon the answer, and then about feeling that it is correct answer. There is no absolute correct answer for any question. Kindly go to Kanpur University's case versus Sajjan Gupta. Even in an objective examination, there can be more than one correct answer to one question. Marks will be awarded to the most correct answer. What is the most correct answer? Most correct answer is what the examiner who sets the question paper, and in case of doubts, the experts to whom reference is made by the Public Service Commission, that is the most correct answer. And in these matters, there cannot be any absolute justice. It is, the concept is comparative justice. Several people would have answered the same question, whether uniform standards have been applied. That yours is the best answer. But ultimately, everybody would have been examined or valued on the same answer. And the effect of your feeling that you have been deprived marks, several others may also have the marks, it's the same thing. As long as there is no specified act of bias or malevolence, the courts cannot micromanage the evaluation. Yes, we feel so many times, even to the university. When we write an examination in the university, I feel that I have to have secured first rank. I may secure or I may not secure. This divergence between expectation of a candidate and evaluation by the body is always there. And there, you cannot say that I got the answer sheet after 4 years from under the Right to Information Act. And that may not be a proper defense in the absence of an allegation of fraud. Yes, every undervaluation does not amount to a fraud. Overall, comparative justice is the key which guides the functioning of selecting bodies. Yes, suppose somebody says that after 10 years it may come to light that a particular professor had committed blunders in evaluation. Like it happened in one case where the chief examiner was required to moderate 10% of answer scripts. He moderated only 10 answer scripts or 16 answer scripts in total. And in all the 16 answer scripts, he had given exorbitant increase in marks. It is not difficult to investigate and find out that it was an act of malevolence. A bona fide error after some years becomes acceptable. Acceptable in the sense it is not condoned, but the remedy is lost. Like your Limitation Act. You may advance 1 crore rupees. One day after expiration of 3 years, you cannot recover. So for everything, there is what is known as time limit. And only good thing in service law is that time limit depends on facts and circumstances of each case. But these facts and circumstances explained by you, I don't think that it would entitle you for challenging after 4 years. If you feel you can still challenge, issue good luck. If the law develops, I will be happy. But somebody may be unhappy also.
That's true. What you said, I am reminded of two sayings. One is, which a common man will not understand, but the student of law would understand. What we say, vigilantabus non dormantibus. That quote helps those who are vigilant and not those who sleep over their rights. And number two,
Yes.
off top, and we say that you cannot wake up just like a Rip Van Winkle or like a Kumkaran for your rights. You have to do it at the right time at the right place. And Trivikram, over to you.
And the best thing is, you see what Lordship Justice Alagiri Swami said in P. Sadashiva Swami's case. There he said, if somebody is aggrieved by promotion of his junior, he should bring the challenge within 6 months to 1 year. And he added, by coming to court after a long time, you cannot unscramble a scrambled egg. I made this statement appearing for the management before one of the judges, honorable judges of my High Court, who knew that I am a pure and strict vegetarian. He said, what you have to do with eggs, I am overruling your objection. He overruled. But see, because in the facts and circumstances of that case, the court felt that delay is justified. Therefore, we should approach towards delay, we should have this approach. By lapse of time, we are trying to unscramble a scrambled egg. Or a thing, we are thinking of disturbing a thing which has attained a coitus.
Vikram?
Sir, I was just thinking, as these are series, we will have to compile every webinar that so far we have had, and we should bring it out as a book, the handbook. That would be helpful for a lot of youngsters, interns, and even practitioners. That is what I was just in a series, and it has been so enriching that we will have to compile and we will have to share it with the.
Instead, I have a proposition.
Yes, sir. Please.
In fact, the lectures I am delivering.
Yes, sir.
Is a draft of a book I am authoring. So, wonderful. I think by the end of this series, book can be released.
Released, yes, sir.
That's good.
That's a much better idea. And we are eagerly awaiting.
Instead of the eggs, we will then have the hen, which will continue to deliver the eggs. So it won't be unscrambling of the egg. So that's a very good news, which I can say that in a cross-examination, Trikram has been able to deliver that you are coming with a book, and we would be eagerly waiting for that.
I never knew him as a criminal practitioner, but still he succeeded.
Yeah, they say practice makes the man perfect, though Trikram was already perfect. So
once again, sir, as usual, it was a scholarly presentation. Thank you so much on my personal behalf, on behalf of Mr. Vikas Chatrat and Beyond Law CLC, sir. Thank you so much.
Thank you.
Thank you.
Thank you, sir. Thank you.